This is one of the most important constitutional cases in a generation, but it also has some deeply compelling human stories at the heart of it. The human stakes really couldn't have been higher in this case. It involved the question of whether states can deny same-sex couples the right to marry, and the court held nationwide that same-sex couples cannot be denied the right to marry, enjoy that right in every state, and enjoy the right to have their marriages recognized in any state. So it's a big, sweeping opinion, almost epic at points in both its language and its reasoning. Justice Kennedy grounds the decision primarily in the Due Process Clause, so the liberty guaranteed by the Due Process Clause, and says there is a fundamental liberty interest in choosing whom to marry, and that includes choosing to marry someone of the same sex. Kennedy says that the right to marry here and the right to choose whom to marry is a fundamental right. It really goes to the heart of the debate between the majority opinion and the dissenting opinion. So there are 4 separate dissenting opinions, and they all really take aim at what they think the court is doing, which is taking an important policy debate out of the hands of the people and the democratic process. It's unusual for the justices to read dissents from the bench, so I think it's significant that the Chief Justice did read his dissent from the bench. It's a really interesting dissent. It really focuses on this question, not of the status of marriage so much as the status and role of the court, and the role of the court in a democratic system. And he says, the petitioners in this case have made very compelling policy arguments and very compelling fairness arguments, and those arguments should be directed at the legislature. And he comes close to saying, if I were a legislator, I might myself vote for same-sex marriage. He doesn't quite say that, but he says, I would listen to those arguments with care if I were sitting in a legislature. But he said, I am not, I'm a judge, and our role is not to weigh in on these social policy debates. Our role is to decide what the Constitution means, and the Constitution has never guaranteed a right to marry someone of the same sex. And Justice Kennedy responds to the dissenters and says, actually, when fundamental rights are at stake, the Constitution, by design, takes those questions away from the democratic process. So fundamental rights don't get put to a vote, right? The ballot box is not how we determine certain sorts of fundamental rights, because those fundamental rights may be unpopular, right? They may involve unpopular positions. So we don't just leave to the democratic process certain questions. And when a right is fundamental, the role of the courts is to decide kind of the contours of that right. It's definitely a landmark decision. I think it's certainly one of the most important constitutional decisions in the last few decades. I think it probably does join the ranks of cases like Loving, which held that the Constitution doesn't allow states to forbid interracial marriage, and maybe even Brown, which is, of course, one of the most important constitutional decisions of all time.